Lagging so bad. Hello. Hi, this is the AT overview of all of this money. Good morning, everyone. Thank you for joining us. Can you all see the PowerPoint? Can you all hear us okay? Lovely. I'm going to pass you off to Rachel. If you have any questions, please raise your hands or pop it into the chat. Thank you.
Well, that's right. Thanks, Sarah. Good afternoon, everyone. My name is Rachel. I'm one of the tenancy solicitors here at Darwin Community Legal Service, and I'll be doing the presentation today on legal avenues and support for tenants experiencing domestic and family violence. So despite what Sarah just said, if you can reserve your questions until the end, and then I can speak to them then, and throughout, if you do have any questions, pop them in the group chat and we can have a look at them at the end as well. Excellent. Forward. I'd like to acknowledge the traditional custodians of the land on which we are meeting today, the Larrakia people, and pay respect to elders both past, present, and emerging. Extend that respect to all Aboriginal and Torres Strait Islander people who are here with us today. First of all, brief overview. As I mentioned, we are at Darwin Community Legal Service, or DCLS, and we have several functions and services under our big umbrella. First of all, we have the Tenants Advice Service. That's the service that I'm a part of. We are an NT-wide legal service for all tenants. As this includes people living in private residential tenancies, whether that's managed by a landlord or a real estate agent, people who are boarding or lodgers, people in caravan parks, people in supported accommodation, such as accommodation for a charitable purpose or crisis accommodation or transitional accommodation, people who are renting through territory housing, so public housing tenants, as well as people living in town camps all throughout the territory. So it's an NT-wide service. We also have our general legal service, which deals with most civil matters, except for family law, but anything else that comes through the door we can usually address. So that's within our office. We have appointments available with our dedicated team that are here, and we also have an after-hours volunteer advice session that deals with the general legal service, as well as tenancy, but you can come and speak to us about that as well. That general legal service is a Darwin and greater sort of Darwin area base, so it's not NT-wide at this stage. And we also have our Seniors and Disability Rights Service, which advocates for assistance for people who are seniors or people who are living with a disability. So they're a really great service. So if you have any questions in relation to those, please feel free to direct them through to our office, and that's the sort of assistance that we can provide. Awesome. So just a brief overview of what we're going to be talking about today. So as many of you know, there was some recent amendments to the Residential Tenancies Act that came in from the 2nd of January this year. So I'm going to be addressing those, as well as some of the things that have not been amended and are existing, but particularly concerning tenants who are experiencing domestic and family violence and the sort of assistance that can be provided to them. So yeah, property damage and other sorts of vicarious liability, termination of the tenancy, locks and security devices, minor safety modifications, privacy, and database listings. Awesome. So starting off with property damage and other sorts of vicarious liability. So a common covenant that's been accepted since the beginning of leases is that tenants are jointly and severally liable. So as we know that if one tenant falls behind on the rent, the other tenants have the responsibility to pick up the slack. The same goes for damage that's caused to the property. So subsection 2 there says tenants responsible for under a tenancy agreement for an act or omission by a person other than a co-tenant who's on the premises with the consent of the tenant and permits or performs or omits to perform an act that would have caused a breach of the agreement. So interestingly, it says with the consent of the tenants, that's obviously somebody who's broken in, they can't be held responsible for that. But you know, if it's, for example, in the context of domestic and family violence, if it is a family member or a partner or whatever that might be, then that law captures them as well. However, subsection 3 has recently been updated. It used to say that when they were giving consideration to the liability of tenants under this section for the vicarious liability of a domestic and family violence perpetrator who has caused damage to the property, for example, it used to be in consideration of the numbers of times that an act of domestic violence had been committed. So it was, you know, there wasn't really any sort of clear indication. It's like, oh, if it happens as a one-off thing, then maybe it's not DV. But if it happens on an ongoing basis that hasn't come up for a while, maybe it's not DV. Nobody really knew. It was a little bit unclear. It was sort of a very, very case-by-case basis. Now it's been changed to say that it's reasonable in all the circumstances for the tenant not to be taken to be responsible under the agreement for the act or omission because the tenant or another occupant of the premises has experienced domestic violence. So that makes it quite clear that it's like if there's any form of domestic violence in place, then the tenant should not be held liable for the perpetrators, the tenant as the victim or as an innocent bystander can't be held responsible for the acts of the perpetrator in causing property damage. So you might ask, how does this experience of domestic violence, how is that proven? This has also been changed. Oh, sorry, before I go on to that, the rest of this section has also been updated so that now landlords can claim directly against the perpetrator through a Small Claims Act. So if it was a co-tenant, for example, that was the perpetrator of domestic violence and had caused the damage, you can sever the liability between the innocent victim who has had the domestic violence committed against them and then the perpetrator, so that the perpetrator could only be held responsible under the Residential Tenancies Act for damage. However, the Act has now gone one step further and said that even though this perpetrator isn't a tenant and there's no claim under the Residential Tenancies Act, the landlord can still bring a claim under the Small Claims Act for the cost of that damage, which is really great news. So back to what I was saying before, there is now a process for establishing experience of domestic violence. This is a new section 4A. So this has been streamlined and it's very conclusive. So for the purposes of the Act, a tenant can establish domestic violence under a court DVO, under the Domestic and Family Violence Act, an injunction under 68B1A and 114(1)A of the Family Law Act. So that's an injunction for the personal protection of a child, and also an injunction for the personal protection of a party to a marriage under that Family Law Act. And a certificate in the approved form by a person with an occupation prescribed in the regulation. So focusing on this last one, part C, this is the approved form here. So this is the certificate that gets filled in. It basically just says, you know, this is the tenant's details, this is where they're living. I solemnly and sincerely declare that the information provided is true. This person is experiencing domestic violence. I understand that it's an offence to lie, etc. And the people who can fill this in and sign it, or sign it as witness for the tenant and the domestic violence they've experienced are these occupations which are listed in the Residential Tenancies regulations. So a health practitioner, a qualified social worker, a police officer, a legal practitioner, or somebody in charge of a domestic and family violence support service. So that's obviously quite a broad range of people who can sign off on this document. We have had to use this document several times since it's came into effect, and it's been really effective. We haven't had any pushback from real estate agents, which has been good. So it's been really amazing changes to protect victims of domestic violence so that they can safely leave their tenancies without incurring unnecessary liability. Cool. So in terms of terminating the tenancy under domestic violence, I'll go through quickly the existing process and then the new process. So this is just a very brief overview of what it is. But in terms of the new and additional process, empowers tenants to do it themselves, and there's not the need to go to the tribunal as there was before. The tenants are not liable after the termination date, but they are liable for anything that's happened before the termination date. And the landlord and the co-tenant can also apply to the tribunal to have the rights and liabilities declared between the parties as well. So it's sort of taking into consideration everybody who's involved in the tenancy. But as separate from the person experiencing domestic violence. So that's worked out quite well. So the existing process is to seek a termination of the tenancy before the end of the fixed term. The tenant can ask for a mutual termination. So this is just an agreement between the parties whereby a tenant who's experiencing domestic and family violence can say, hi, real estate agent or landlord, I'm experiencing domestic and family violence. Like, can you please have a heart and let me out of this tenancy early? That we have had some success doing that in the past. And, if they recognise that it's the best for all parties to have someone away safely, then that works out quite well. However, the real estate agent and the landlord are within their rights to decline that. Another way is to assign the interest in the tenancy. So that's discussed at length in sections 78 to 81, whereby a tenant can ask to assign their interest and have another tenant essentially step into their shoes. So that works out well if you know somebody who's happy to take over the property. That isn't always practical for tenants to do. And the other way is an abandonment, or also called a lease break, which is where the tenant terminates the tenancy without the consent of the landlord. Basically, just hand the keys back, move out, stop paying rent. That's the end of the liability. That also has, issues and bond and seeking lease break associated costs and that sort of stuff. I'm not going to go into that at length because we'll do another presentation of bonds in the near future, I'm very sure. But that's also just more risk to the tenant and not being able to get their bond back in the event of a lease break. The other way to end a tenancy early is through hardship, which is discussed, which is outlined at section 99. So I've put the whole section there. So the onus is on the party to bring the application to establish that in the first instance, the continuation of the tenancy would result in undue hardship to the landlord or the tenant, whoever it is that's bringing the application, and that the circumstances of the hardship have not arisen before the time of entering into the agreement. So this, just to be clear, this application can be brought by either the tenant or the landlord to terminate the tenancy on the basis of that party's undue hardship. So this section was recently updated to now include a definition of what undue hardship was. Before that, we had to rely on the case law. So I ran a case with a client last year, and it was conclusively said that financial hardship does not count as undue hardship. So we're kicking ourselves now that this has been updated and financial hardship is included as undue hardship. And it also says that undue hardship includes a risk to physical, psychological, or mental health or to safety. So in the past, in previous case law, domestic and family violence was a reason that a tenant could terminate the tenancy early, taking into consideration the interests of both parties. So the leading case in relation to hardship is this case here. So the names have also been suppressed before it was published. This was a really horrific case. So tenant experiencing domestic violence by their ex-partner who was the perpetrator, and the co-tenant felt really unsafe, and it was just a really horrible situation. So we pulled out the really key points of this decision, is that it's a well-established principle that statutory interpretation that legislation is presumed not to interfere with vested proprietary rights. And in any case where section 99 is invoked, there remains the need for careful weighing of the respective interests of the party suffering hardship and the party who will necessarily be disadvantaged by termination. It is only after those interests have been weighed that there can be proper decision as to whether the hardship is undue according to the usual meaning of that word. So that weighing of the parties is very important in looking at this is the circumstances surrounding the tenant or the landlord who's applying for the hardship, and then the other party who is going to be disadvantaged by the tenancy ending early. So as I mentioned in the past, we've had Oh, sorry. I've got it on my bad. Oops. So in the past, we've had several successful terminations under Section 99 from the tenant experiencing domestic violence, on the basis that, you know, the tenant's putting at risk to life and limb by staying in the property, and then also the ongoing financial hardship of having to pay rent in a property that they don't want to be living in anymore. In comparison to the landlord, for example, could only ever experience financial hardship in those circumstances. I did want to raise very briefly that I had a hearing a couple of weeks ago where a landlord was attempting to terminate the tenancy on the basis that they had experienced domestic violence and wanted to move out of their property that they were living with their partner, the perpetrator, and back into the property that they owned where the tenants were currently living. So that was, yeah, a really interesting case in that there was, you know, it was established very clearly that the landlord was absolutely experiencing domestic violence. That was not an issue. However, in weighing of the circumstances, you know, they had a full-time job. They hadn't been paying rent in this property where they were living with their partner. They had received enormous support from other domestic violence support services and that sort of stuff. Whereas my clients, the tenants, were both in between jobs and had enough money to sustain the tenancy at their current rent, but couldn't move somewhere more expensive in the height of the dry season. They had a dog that would have been harder to place and all that sort of stuff. But ultimately, it came down to the fact that it's satisfying that subsection B of Section 99(1) is that the hardship hadn't arisen before the commencement of the tenancy. Ultimately, this landlord had entered into this abusive relationship several years before the tenancy commenced. And as when she decided to enter into the tenancy with the tenants, the domestic violence was already on foot. So that was automatically dismissed Section 99. But in considering that continuation of the weighing of the interest between the parties, the tribunal member made this really great comment that, in my view, the amendment, so that's bringing in the new definition of undue hardship, does not absolve the tribunal from weighing the interests of the applicant suffering undue hardship and the interests of the respondent, including the extent the respondent will be disadvantaged by the termination determining whether to make an order under Section 99 of the Act. So they've said, even though on the face of it, financial hardship and, you know, the risk to physical, personal, psychological safety has now been included, that weighing act between the interests of the parties is still the most important factor. So considering that, first of all, has the hardship happened before the commencement of the tenancy? That's usually pretty apparent whether or not that's happened. But then that weighing interest is more about putting the legal arguments forward in that, you know, let's look at, you know, the position that either of these parties are in. So ultimately, the landlord's application was dismissed on the basis that they were not as financially disadvantaged as the tenants, in that they had other housing options to go to, and that the tenancy was ending in November. So all she had to do was wait until November, and then she would be able to get back into her own house. So the tribunal found in those instances that, yes, even though she was in a horrible position of experiencing domestic and family violence, it wasn't so much as to displace the tenants from their home. So just a brief note on that. But yes, I haven't been able to cite the decision because it was suppressed due to the sensitive nature of the case at the request of the landlord. But I just wanted to pull out that really great quote from the member. Awesome. So another way to terminate a tenancy early is through the Domestic and Family Violence Act. So this used to be the sort of, not the best way, but the way to do it, in that the tenancy could be amended as opposed to terminated. So the court can order that the tenancy be terminated and a new one be immediately entered into. So that can either be that the perpetrator wants to stay in the property or the tenant wants to stay in the property. So this is most relevant in the event that the perpetrator and the victim are both co-tenants and are both, you know, have responsibilities under the lease. So that was the way to do that. And the replacement agreement needed to be identical to the original agreement. So the rent had to remain the same. You know, it could be decreased because there was only one person paying it, and it could be extended, all that sort of stuff. So that was the power of the court under the Domestic and Family Violence Act. This is in comparison to doing the hardship application under NTCAT, where the NTCAT can only terminate the tenancy, considering the landlord, the tenant, any co-tenants, and they couldn't order for the tenancy to be re-entered into or amended in any other way. So that was obviously a bit of an issue in that, what about everybody else who was living in the properties? There was a few domestic violence hardship cases that were knocked back on that basis, that it was like, well, nobody else, what about the other tenants? They wouldn't have anywhere to go. So it would just have to be that one person who left if that were the case. And there's also the issue of termination of the tenancy puts tenants at risk of being listed on the tenancy blacklist as well. So despite all of that, so all of those things are still in effect. You can still terminate a tenancy early by mutual termination, assigning the interest, or by breaking the lease, as well as a hardship application, as well as an application under the Domestic and Family Violence Act. All of those things you can still do. However, now the Residential Tenancies Act has been updated with this new section 92A, which has made it so much more streamlined and straightforward for people experiencing domestic and family violence to be able to terminate the tenancy. So I put it here in its entirety. But yeah, the tenant may terminate the tenant's interest in the tenancy immediately or by a later date by giving notice to the landlord and proof that the tenant has experienced domestic violence. The tenant continues to be liable up until the tenancy agreement has ended, but not afterwards. The tribunal can make a declaration of the rights and liabilities between the co-tenants, if there's any after the tenancy is ended, or up until the tenancy ends. And then the tenancy agreement can remain in place with the tenants, the existing tenants, or they can choose to terminate the tenancy as well. So all of this is a little bit confusing, which is why my wonderful colleague Al has put it in an easy table for us all to follow. So essentially, the tenant needs to give the landlord the RT06 notice. That's a notice of intention to terminate the tenancy agreement by the tenant to the landlord / agent. So this is specifically in relation to domestic and family violence. And as well as the certificate establishing domestic violence that I mentioned before under section 4A. That's the two documents. The tenant just gives that to the landlord that says, on this date, which may be today or maybe 2 weeks in the future when I move into my new place, this is when the tenancy is going to be ending on the basis that I've experienced domestic and family violence, which is so much more streamlined than having to go through the tribunal or, beg the landlord for a mutual termination, whatever it might be. Then you need to take into consideration whether there's any other tenants on the lease, so any co-tenants. They also need to be given a form, so that's the RT06B, that says to tenants, I, as your co-tenant, I'm terminating my interest in the tenancy agreement. And here's the certificate establishing that I'm experiencing domestic and family violence. And then it's up to the remaining co-tenants, if any, on the lease, if they want to continue the tenancy without the person who's left because of domestic and family violence. So it might suit them to stay, or they might want to leave because, the perpetrator they feel unsafe or whatever the reason might be. So if that's the case, then the tenant can also give the landlord a notice to terminate the tenancy agreement, which is called an RT06C. So that sort of just stepped out on the side there of what the process is. So we've, as I mentioned before, we've had some success already with the certificate and the termination. As far as I'm aware, I don't think we've had any clients come through who've been co-tenants and needed to do the co-tenant path. But the fact that it's been streamlined in this way is a really great amendment that we're very, very happy with. So yes. Moving on now away from terminating the tenancy early. So I feel like I spoke at length about the old way and how hard it was, and then this new way is so streamlined that it didn't need to be given as much attention, but it's obviously very, very important. So moving on now to other aspects of the Residential Tenancies Act where domestic and family violence is directly relevant. So this is under section 49, so landlord's obligation regarding the locks and security devices. So this has been recently updated in January as well, that it used to be the landlord would change the locks and say, and they have to give a copy to the tenant, but there was no time frame. So now it's saying that if a landlord's choosing they're changing the locks, they have to give the tenant a copy of the keys within 24 hours. So that's wrapped up a lot quicker, instead of, tenants potentially going, weeks or more, whatever it might be. Another amendment to this section is that it empowers the tenants to stop the landlord from providing keys to a specific person other than a tenant if they're under a reasonable apprehension of experiencing domestic and family violence. This section of the Act is a little bit confusing, and I think the intention of it is not very clear. So just to read directly from subsection 6 and 7 of section 49, a tenant may advise the landlord in writing not to give a key to the premises to a nominated person if the tenant or another occupant of the premises is under a reasonable apprehension of experiencing domestic violence from that nominated person. If a landlord is required to provide a key to the premises to any person other than a tenant in order to carry out an obligation under this Act or a tenancy agreement, the landlord must give the key to any person nominated under subsection 6. So the way that we understand this is that the landlord can't not give a co-tenant a key. So that doesn't help when the perpetrator of domestic and family violence is a co-tenant. However, it can, even if it is, for the purposes of doing their other obligations of the Act, such as repairs, then they don't have to give a key to that person. So we're kind of calling this the cable guy clause, that if it's like a tradie or something who's the potential perpetrator or is putting the tenant at risk of experiencing domestic and family violence, then that could be the exception there. But I think, the intent of that is a little bit confusing and seems to only apply in very narrow circumstances, but it's a win either way. So section 52 of the Act has also been recently updated as of January, which empowers tenants to alter, remove or add security locks or devices without the landlord's consent if they have a reasonable excuse for not doing so. So, if somebody breaks in, perpetrator breaks in, or, the victim kicks them out or whatever it might be, and they just want to change the locks, that's probably a pretty reasonable excuse to do so. The landlord, so in saying that, like, they still have to provide a replacement key to the landlord within 2 business days. The landlord is entitled to have a copy of the key to the property in which they are renting out. However, there is an exemption to this, if the tenant changes the locks, they don't have to give a key to the landlord if the landlord is the person who's committing domestic and family violence, or there's a good belief that the landlord will commit domestic and family violence. I'd like to say that this isn't a situation that would ever arise, but it has, and it does. We had a case recently where a big rural property, my client was living with 3 children, and it became apparent that the landlord was sexually abusing the children, and that would be when this would become relevant, is that the tenant is allowed to change the lock so that the landlord can't come up to our property anymore. So yes, that was a really great update. Section 52 further introduces the making of minor safety and security modifications as a term of the tenancy agreement. So the landlord, so if you're making a modification as a tenant for safety and security, unless the landlord has said, oh yeah, that's fine. If you want to install, a really expensive print safe stuff to all the windows and doors, absolutely keep it there. It's obviously increasing the value of the tenancy of the property, but normally, unless the landlord has agreed otherwise, the tenant can put it back to the way it was before. So I'll go through it in a minute, but the process for obtaining the landlord's consent, and then this is the type of modifications that tenants are allowed to make. Safety, security cameras and alarm systems, securing out of furniture to the wall, that kind of seems common sense, and replacing window dressings or anything similar. So I think, these ones are probably the most common ones that might arise as a safety and security modification. But then the example that I used before, for example, of, prim safe screening and stuff like that would fall under, as a similar modification. So the tenant does still have to, seek the consent of the landlord. So the tenant has to give a request to the landlord, and the landlord has to consider it without delay, or within 10 business days, whatever happens to be sooner. The landlord can't unreasonably refuse to the modifications. The landlords can give their consent subject to reasonable conditions, and if no response within 10 business days, then consent is deemed to have been granted. So if the request is refused or granted subject to conditions, then either party can apply to the tribunal, and the tribunal can make a determination that the landlord's refusal was unreasonable and make an order to authorize the modifications, or the tribunal can make a declaration that the landlord's conditions were reasonable, and revoke the conditions and impose the rule. So the tribunal has quite broad powers there to be able to look at what is being asked for. But I haven't seen this in practice yet, as it's a fairly new modification, a fairly new amendment to the Act to be able to make these modifications. But it's happened quite a few times before where tenants want to install security cameras because, you know, they maybe live in a dodgy neighborhood, or, you know, they've had risks of break-ins in the past and that sort of stuff. That's the sort of thing that they can now ask for a consent from the landlord, and there's without any sort of reasonable excuse. There's not really any reason why the landlord wouldn't permit that. You know, if it was like a heritage listed house or something, then that might be a reason, but otherwise that would be an unreasonable refusal should the landlord not allow it. But again, it sort of does come down to the circumstances of the case, and because we haven't really seen any, we don't really know what those are just yet. Cool. So there's been new amendments to bring in the privacy of people experiencing domestic and family violence, as well as everyone who's living in tenancies. So the new section 18A in the process of applying for a tenancy, the Commissioner of Tenancies, who sits under Consumer Affairs, may approve a class of information of which the landlord can ask for, and the landlord can't be asking for information other than what's in that class. As far as I'm aware, this class of information hasn't been published or hasn't been like put out yet, so we don't know what that's going to be. But you know, if it's information that landlords are asking for, like, please say all the times that you've been in a domestic and family violence relationship, that's obviously not appropriate, and hopefully is not included in the class of information coming forward. And that would be discrimination in any event. So after applying for tenancy, and if you're not successful and you don't get the tenancy, the landlord's got to destroy all of your information that you provided within 5 business days. So they can't just be keeping your personal details on file. And as we know, a lot of the information that is being asked for by real estate agents in particular, like, you know, income statements for the past however many years, like all the properties that you've lived in, you know, that sort of stuff is really personal information, and, you know, dodgy things can be done with that sort of information that people know about you. So it's really good now that that's been introduced, that the landlord's got to destroy that within 5 business days. How that gets policed is a different story, but the landlords, you know, they've got an obligation to do that now. There's a new section 18B for the keeping of tenant information, and this does have penalty units attached to it. So the landlord must take reasonable steps to protect the personal information from misuse. So making sure that, you know, it's not being kept in an insecure location, or, you know, leave it open on your desktop in the middle of a busy office or whatever that might be. Must provide a copy of any information or documents relating to the tenancy within 5 business days. The tenant has a right to ask for that information. The landlords must amend or remove inaccurate information or destroy inaccurate documents within 28 days of the tenant's request, if that request is reasonable. If, for example, you know, the landlord's got, you know, maybe a tenancy reference that says arrears or something, and the tenant pays them off, you know, so that they're less, or whatever that might be. That could be an example of having that information updated so that it is accurate and up to date, and isn't going to, you know, prejudice the tenant. It could also be like, you know, how many people are living in the house, that sort of stuff. And if the request is reasonable in the circumstances, this hasn't been gone through the tribunal as far as we're aware, so we don't know what that sort of reasonable circumstances might look like. And then the landlord can't just keep all of that information about the tenant forever. It's got to be destroyed 3 years after the tenancy ends. So that's the limitation period for bringing in action under the Residential Tenancies Act. So destroying it after 3 years, there's no more the limitation period is over, there's no more action that can be taken, that information should be destroyed. Cool. More privacy protections. There's a new section 74A, which puts restrictions on the use of images and videos. So the landlord, without the tenant's written consent, cannot publish or publicly display images which reveals identifies or reveals sensitive information about the tenant or another occupant. Yeah, I guess there's a million examples of that, but if you're the only person in town who owns Picasso and there's a video in your house with a Picasso, then that could be it. Random example, but along those lines. Again, Picasso example is valuable and increased theft. If you've got an original Picasso in your house, you're probably going to have a bit of a target on your back if that's been advertised everywhere. It would be unreasonable to expect the tenant to remove or conceal. So that's any sort of, large furniture or anything else that, if the tenant, for example, doesn't want their pole dancing pole in advertisements for the property or something like that, but they can't remove it, then that wouldn't be the landlord then can publish or publicly display those images, or if there's any information which may identify a tenant who has experienced or is at risk of experiencing domestic and family violence. So I guess that's where, if a tenant has quite distinctive furniture that the perpetrator has obviously seen in their house before, that would be that sort of example. So a tenant is allowed to review these images or videos prior to giving their consent. So I guess, after they've seen it and they've been like, oh yeah, that's actually fine. You can't really tell that that's my place, or nah, you guys have captured all of my personal belongings. I don't want this to be published. They're allowed to do so. And the consent that the tenant gives is valid for 12 months or any lesser period. So, if, for example, perpetrator's away from Darwin for 6 months or whatever, the tenant's like, yeah, that's fine. I'm happy for this to be advertised in 6 months, but then I know they're going to be back in town and I don't want my, these images of the inside of my home anywhere during that time. That's a bit of an example. I did have this issue arise the other day where I had a tenant who was subject, or the landlord was doing an inspection and came in and started taking pictures of the inside of the property, under the sink to see if there's any leaks, like, a few things that needed to be repaired, that sort of stuff. And she wasn't comfortable with that happening because all of her belongings were in it. But ultimately, this section doesn't stop that from happening. The landlord's obviously taking the pictures for the purposes of doing a condition report or a routine inspection. And I don't think it's unreasonable for the landlord to be taking pictures of the property for the purposes of comparing it to last time, etc., or to, be like, oh, this is a repair that needs to be done, let's take a picture of that. So I think that this section here, by very clearly saying cannot publish or publicly display images or videos, excludes any sort of private images or images that wouldn't be otherwise publicly displayed for the purposes of a condition report and that sort of stuff. So unfortunately, I had to tell the tenant that there's not much to be done in these circumstances, but it's only in relation to publishing or publicly display the contents of those images. Cool. So tenancy database listings. So just a crash course on databases is that the most common one is called TICA, T-I-C-A, and it's where landlords can sort of essentially blacklist tenants who are bad tenants. I know that I don't think that private landlords use these very often because you do have to pay a fee, but it's quite common for real estate agents to check TICA databases to see if the tenant has been listed as a bad tenant or previous tenancy, and then they can be excluded from being offered a tenancy on that basis. So obviously it puts the landlords in an extreme position of power in that there's no landlord blacklist. Purple Pingers from who's influencer based in Melbourne has started up shit rentals, which is where tenants can list their own rental property or a real estate agency as a bit of a name and shame list, which I personally think is really cool. And I sometimes have a wee look at the anti ones and I'm like, oh, spicy. But yeah, so that's obviously not a official or formal blacklist like TICA is. So it puts tenants at an extreme disadvantage in potentially finding future rental properties. So this section has recently been, the sections in the act that deal with tenancy databases have recently been updated to clarify when a tenant can be listed on a tenancy database. So before we were seeing it all the time that real estate agents would just say, hey tenant, you owe all of this money because we're doing all of these maintenance and repairs to the property in the 10 years that you've lived here, etc. So you owe us $15,000. If you don't pay this, you'll be listed on a blacklist. So we've had a few clients who've just paid it because they don't want to be listed on a blacklist. And obviously there was no proof that they had to pay any of those things. We've had other tenants who come back and said, oh, get stopped, I'm not paying that, like prove it that I need to pay it, and they've been listed anyway. So now in other jurisdictions in Australia, it was quite clear for precedent or the legislation in those jurisdictions that it had to be substantiated that the tenant was owing money, whereas that wasn't the case in the NT. So we ran a test case in the tribunal last year, and the tribunal agreed with the precedent in other jurisdictions that this needed to be substantiated, that the tenant was to owed the money and could be blacklisted. However, the Residential Tenancies Act has been updated to reflect that, to make it really clear, which is really good. So there's also so to be able to be blacklisted, a person must have been a tenant at the time of the breach. So that, like, not only are they just a tenant on the tenancy agreement, but they must have been living there at the time. And they either agree in writing to be listed on a tenancy blacklist, or NTCAT has found that the tenant personally breached the tenancy agreement, resulting in owing more money than what the bond is, or the tribunal has ordered the termination of the tenancy. So that owing more money than what the bond is was that example before, is that, this landlord, if the landlord was to take the tenant to the tribunal and say, yep, they owe me $15,000 for all of this maintenance stuff that I've had to do for the property. And the tribunal said, oh, no, actually, that's not the case. The tenant doesn't owe you that money, then they can't be blacklisted on the blacklist on the tenancy databases, or the termination of the tenancy. So that's what I mentioned before, that when a tenancy was terminated under Section 99 on the basis of hardship, if that's for domestic and family violence, there was still the risk of being able to be listed on a tenancy blacklist for that. So just in relation to that as well, NTCAT can order the removal of a listing if a person has experienced domestic and family violence and was not personally responsible for the breach. So that's where that liability under Section 12 comes in again. So that's Section 134 2A, is that if the person has experienced domestic and family violence and it wasn't their fault, then the tribunal can order that that person can be removed from that blacklist, which is really great news. So it's also been streamlined. So before it used to just be that the landlord or the real estate agent would have to have given, I think it was 28 days notice to the tenant that they were going to be blacklisted. Now it has to be in the approved form from this document, which I think I can't quite see the top, but it's a RT0 something form. And that's from the Consumer Affairs website. So now it says really clearly, tenant, this is you, this is your details, we're the landlord, this is where we're based, this is what we're intending to put on the tenancy database about you. And the Act is quite clear in that it has to be unambiguous, complete and accurate information. So it can't just be, tenant's awful or whatever it is. It's got to be, tenant left the tenancy owing more than the bond by, $10,000 or whatever that might be, but that also again has to be substantiated. And then this part 2 down here has also made it really clear that of the reasons for listings is that you've agreed to be listed, or the tribunal has found that you've breached the tenancy agreement. So that makes it really clear that it's like, yep, landlords, real estate agents, you've got to go through the tribunal if you want to have any sort of claim for listing these people if they've not agreed to it. So those are some really great amendments as well. That's just brought so much clarity and has alleviated a lot of stress for tenants. We see it all the time that tenants come through and they're like, oh, but if I ask for this to be repaired, like, am I going to get listed on a blacklist? Or, if I break the lease, am I going to get listed on a blacklist? It's like, no, like the landlord and the real estate agent have to go through this process to be able to list you on anything, at which stage come back and speak to us. That's something that we can argue and we can fight against if need be. Cool, so that wraps up the substantive law part of my presentation. I realized that I spoke pretty quickly, sorry. But just moving forward, if you do need assistance or you do have clients who need assistance in these areas, please see this list of acronyms on the left. Basically, all of these legal services they're all NT legal services, sorry, and they all have the ability, they're all free and they all have the ability to assist, obviously dependent on capacity. So I've just got a little note here that if DV and a DVO or etc. are the substantive grounds of the legal issue, then direct in the first instance to a DBLS or another women's legal service if it's women, etc. However, if a DVO is part of the issue but not the major issue, and the tenancy part of it is the major legal issue, that's come to us. That's the sort of stuff that we can deal with immediately. We do work really closely with these other services in relation to DVOs and that sort of stuff. So we can collaborate and do cross team thinking. More minds are better than less minds. So that's definitely the sort of thing we can help with. But if tenancy is the foremost issue, then come to the tenancy advice service at TCLS in the first instance. Cool. We've also recently updated our fact sheets on our new website, which I believe launched a couple of days ago, which is exciting. So all of this information that I provided is going to be up there. So if you do need to review this information again, in the first instance, check out that. It's a really great resource. Or like I said before, you yourselves or have your clients to call us for an appointment. We usually have the ability to see clients on an urgent basis. If it's like, this tenant needs to move out tomorrow because they're really unsafe, or if they've got a tribunal hearing the next day, we do have capacity to be able to assist on an urgent basis if need be. Cool. Also, just a quick plug of our Make Renting Fair in the NT campaign. This is in advance of the elections that are coming up. So we're just trying to grab some information from people who are renting in the NT of what their experiences are like. So we've had this survey published for it's probably like just over 6 months now, and we've got some really great responses. So if you wouldn't mind again, if you're renting in territory and you haven't filled it out, please do so, and please spread it amongst your networks as well. Awesome. So that brings me to the end of the substantive content of my presentation. Does anyone have any questions? Yeah, if you've got any questions, chuck them in the chat or raise your hand and I can speak to them. Thank you. Thank you. Cool. Awesome. So on the basis that there's no questions, and if it's a question that you have in relation to a particular client, or maybe you don't want to say to the entire group, that's totally fine. Yeah, send us an email, give us a call, and that's something that we can address in a more private setting. But thank you all very, very much for your attendance. I'm happy to be wrapping up a few minutes early. I'm certain that you are as well. But thank you very much for your time. Keep an eye out on the socials and other platforms for more presentations that come from us. I understand that we do these every month on a range of the legal issues and legal and other issues that we come across here at DCLS. So that more information on the next one will be coming out shortly. But in the meantime, thank you very much for your attendance and enjoy the rest of your day.
Thank you.